On February 12, 2026, a federal judge delivered a direct and highly consequential rebuke to President Donald Trump, denying his attempt to delay proceedings in his $10 billion defamation lawsuit against the BBC and ordering the case to move forward toward a scheduled February 2027 trial. The ruling rejected Trump's request for a stay that would have paused discovery, meaning his legal team must now comply with document production, depositions, and evidentiary deadlines under standard federal civil procedure. The judge made clear that high office does not entitle a plaintiff, even a sitting president, to special treatment in civil litigation he initiated himself. That single line, buried inside a procedural order, sent a powerful signal. If Trump chooses to sue, he must follow the same rules as anyone else. The court emphasized that the litigation was filed voluntarily by Trump and that claims of executive burden do not automatically justify suspending judicial timelines. In blunt terms, the judiciary refused to let presidential status become a shield against procedural accountability. This rebuke lands amid a broader pattern of judicial resistance to expansive executive assertions since Trump returned to the White House in January 2025. Federal courts across multiple circuits have scrutinized executive actions on immigration, federal appointments, and agency authority, with several rulings sharply limiting administrative reach. In late 2025, a federal appeals panel invalidated Trump's controversial appointment structure for certain top prosecutors, finding it inconsistent with statutory appointment requirements and separation of powers principles, which led to the collapse of high-profile indictments that had relied on that authority. The decision was widely interpreted as a structural setback because it did not merely criticize policy, it struck at the legality of how power was being exercised. When appellate courts begin dismantling the framework of executive implementation rather than just isolated actions, the impact becomes systemic, not symbolic. The February 2026 decision is particularly striking because Trump's legal team argued that ongoing presidential duties justified pausing litigation timelines. The judge rejected that reasoning, pointing out that the presidency does not nullify federal procedural obligations in cases initiated by the president himself. Legal analysts immediately noted the broader implication. If courts grant routine stays based on workload claims, any officeholder could strategically delay proceedings indefinitely. By refusing the stay, the court preserved the principle that civil courts operate independently of political calendars. It also guarantees that discovery, potentially including internal communications and evidentiary disclosures, proceeds under judicial supervision rather than executive discretion. That development alone transforms the case from political theater into enforceable litigation risk. Compounding the pressure, recent federal rulings have also pushed back against executive immigration directives, ordering procedural safeguards restored for deported individuals whose due process rights were questioned. In another instance, a federal court required continued funding compliance for certain benefit programs after reviewing statutory mandates. Taken together, these rulings reflect a judiciary increasingly willing to assert boundaries when executive interpretations stretch statutory text. The pattern matters because cumulative rebukes shape precedent and embolden lower courts to apply stricter scrutiny in subsequent disputes. What makes this moment explosive is not just one denied motion, it is the convergence of judicial skepticism across multiple arenas. The top court has already signaled heightened interest in clarifying limits on executive authority in pending appeals tied to immigration enforcement and agency discretion. If those cases produce narrowing opinions, the administration's operational flexibility could shrink even further. The February 12 ruling therefore operates on two levels. Immediately, it forces Trump's defamation lawsuit forward under court control. Strategically, it underscores that presidential status does not override procedural law. For supporters, it is a legal hurdle. For critics, it is evidence of constitutional guardrails functioning as designed. And for the broader political landscape, it marks another unmistakable moment where the judiciary, not the executive, dictates the pace and parameters of accountability. The February 12, 2026 rebuke did not materialize out of nowhere. It was the culmination of mounting judicial friction that has been building since Donald Trump returned to office in January 2025. and began aggressively testing the outer edges of executive authority. Within weeks of his inauguration, a series of executive directives, particularly in immigration enforcement and federal personnel restructuring, triggered immediate lawsuits in federal district courts from California to Washington, D.C. Judges began issuing temporary restraining orders at a pace reminiscent of the early months of Trump's first term, but this time with sharper language and narrower tolerance for procedural shortcuts. Several courts emphasized that statutory limits passed by Congress remain binding regardless of campaign promises, and that administrative agencies cannot bypass notice and comment rulemaking requirements simply by invoking urgency. That early pushback signaled a judiciary alert to patterns seen before, and unwilling to defer automatically. By mid-2025, the legal confrontation intensified when questions emerged over the administration's appointment of certain interim federal prosecutors and senior Justice Department officials. In November 2025, a federal appellate panel ruled that one appointment mechanism relied on by the administration did not align with the Appointments Clause and governing federal statutes, effectively invalidating prosecutorial authority in specific cases that had already moved forward. The fallout was immediate. Indictments tied to that authority were dismissed or paused pending review, creating embarrassment for the administration and raising concerns about legal vetting at the highest levels. The ruling did not merely criticize a policy outcome, it questioned the structural legality of how executive power was being exercised. Legal scholars noted that such decisions carry ripple effects because they set binding precedent within the circuit and influence parallel litigation elsewhere. At the same time, immigration enforcement actions became flashpoints for due process challenges. In early 2026, a federal judge ordered the government to provide procedural remedies in cases where deported individuals alleged they were removed without adequate hearings or statutory review protections. The court's reasoning focused not on policy preference but on constitutional guarantees embedded in the Fifth Amendment. Judges stressed that executive urgency does not extinguish procedural safeguards. That framing matters because it places constitutional process above political priority, a recurring theme in recent rulings. In several written opinions, courts underscored that adherence to statutory text is not optional and that executive discretion must operate within clearly defined boundaries set by Congress. Another critical layer involves repeated judicial scrutiny of administrative agency actions. Federal courts reviewing regulatory changes in 2025 and early 2026 increasingly invoked the Administrative Procedure Act's arbitrary and capricious standard, scrutinizing whether agencies provided sufficient factual justification and reasoned analysis before implementing sweeping reversals of prior rules. In more than one instance, judges concluded that agencies failed to adequately explain departures from established precedent or to account for reliance interests affected by abrupt changes. These findings reflect a judiciary that is demanding detailed evidentiary records rather than accepting broad assertions of executive necessity. The effect is cumulative. Each ruling narrows interpretive flexibility and signals to agencies that shortcuts will not survive judicial review. Against that backdrop, Trump's attempt to pause his own $10 billion defamation lawsuit proceedings appeared to judges as part of a larger pattern, asserting expansive discretion while resisting procedural constraint. The February 12 denial of a stay reinforced the message already embedded in months of appellate and district court decisions. Executive status does not suspend judicial authority, and litigation initiated by the president must proceed under the same civil rules that govern any private citizen. Observers inside the legal community noted that courts are increasingly writing opinions that emphasize institutional balance, often referencing separation of powers principles explicitly rather than implicitly. That rhetorical shift is significant because it frames these disputes not as partisan clashes, but as constitutional boundary enforcement. What the public may not fully appreciate is how interconnected these rulings are. Each denied motion, each invalidated appointment, each injunction contributes to a developing judicial narrative that executive ambition will be met with structured review. The origins of this moment lie in that steady accumulation of precedents throughout 2025 and early 2026, warnings embedded in written opinions, deadlines that were not extended, procedural demands that were not waived. The February rebuke was not sudden. It was the logical escalation of a judiciary that has signaled repeatedly that process matters, statutes matter, and constitutional structure matters even, and especially, when the president is the one pressing the limits. The legal confrontation surrounding Donald Trump is no longer confined to courtroom transcripts and procedural motions. It is spilling outward, producing measurable human and institutional consequences that ripple far beyond Washington. When federal courts block, delay, or narrow executive actions, the immediate result is uncertainty, and uncertainty carries economic and social cost. In early 2026, after multiple district courts intervened in immigration enforcement directives, federal agencies were forced to revise operational guidance midstream, temporarily pausing removals in specific categories while compliance reviews were conducted. For affected families, that pause meant instability, some facing renewed hearings, others navigating legal limbo while policy interpretation shifted under judicial supervision. Court orders emphasizing due process protections required agencies to allocate additional personnel to case review and documentation, diverting resources and stretching already strained administrative systems. Legal aid groups reported surges in inquiries from migrants unsure whether previous enforcement notices remained valid under evolving rulings, illustrating how constitutional checks translate into day-to-day confusion for real people. Economic effects followed closely behind. When appellate decisions in late 2025 invalidated aspects of federal prosecutorial appointments, several high-profile cases collapsed or stalled, sending shockwaves through local jurisdictions where those prosecutions had influenced regulatory compliance and financial settlements. Businesses that had been negotiating under the expectation of active federal cases suddenly faced altered legal landscapes. Corporate compliance officers described a regulatory whiplash effect, preparing for enforcement actions one month and recalibrating risk exposure the next after judicial reversals. The credibility of enforcement mechanisms matters in markets. When appointment structures are struck down, even temporarily, it injects unpredictability into contractual negotiations, settlement strategies, and corporate governance planning. Analysts noted that federal prosecutorial continuity is not abstract. It underpins investor confidence in consistent rule application. The February 12, 2026 ruling denying Trump's request to pause his $10 billion defamation lawsuit also carries institutional consequences. Because discovery will proceed under court oversight, legal teams on both sides must engage in document exchanges, depositions, and evidentiary filings on a fixed schedule heading toward the February 2027 trial date. That timeline ensures sustained media scrutiny and prolonged allocation of executive legal resources. White House counsel's office staff and outside attorneys must devote significant attention to litigation logistics while governing responsibilities continue, creating operational strain. Critics argue that initiating expansive private litigation while occupying the presidency inevitably intertwines governance with personal legal strategy, while supporters contend that access to courts is a constitutional right. Either way, the judiciary's refusal to grant delay locks in a multi-year legal engagement that will unfold publicly and incrementally. Federal benefit programs have also intersected with judicial review during this period. In early 2026, a district court required continued compliance with statutory funding mandates for certain assistance programs after plaintiffs challenged administrative adjustments. Agencies were compelled to issue corrective guidance clarifying benefit continuity while appeals progressed. For recipients, even temporary ambiguity over eligibility or payment timing can disrupt household stability. Rent schedules, food access, and medical appointments hinge on predictable support flows. Court-ordered clarifications stabilize legality, but can also expose the fragility of systems dependent on executive interpretation. Each injunction underscores how quickly policy shifts reverberate through millions of individual circumstances. The broader institutional fallout is equally significant. Judges across multiple circuits have written opinions invoking separation of powers principles with unusual directness, signaling a judiciary increasingly conscious of its role in boundary enforcement. That tone influences future litigation. When courts articulate firm standards, agencies must draft more defensively, building detailed administrative records to withstand scrutiny. The result is slower policymaking, heightened legal review inside executive departments, and expanded reliance on career civil servants and constitutional counsel. Government efficiency and constitutional caution now operate in visible tension. Public confidence becomes another casualty in prolonged constitutional clashes. Surveys conducted in early 2026 show growing polarization in trust toward both executive leadership and federal courts, depending on partisan alignment. When rulings repeatedly check presidential initiatives, supporters may perceive obstruction, while opponents see constitutional correction. That divergence affects civic cohesion. The people most directly impacted: immigrants awaiting hearings, employees tied to federal enforcement cases, families relying on benefit clarity, experience the system not as theory but as disruption, delay, or relief depending on outcome. And yet, beneath the turbulence, one reality remains constant: judicial intervention is not symbolic. It reshapes timelines, reallocates government resources, influences market calculations, and alters the daily lives of citizens and non-citizens alike. The fallout from these rulings is unfolding in courtrooms, agencies, communities, and households simultaneously, a vivid reminder that constitutional disputes are never merely abstract arguments. They are catalysts for tangible consequences that ripple across the entire national framework. Accountability now sits at the center of this escalating legal confrontation, and the focus returns directly to Donald Trump, whose legal strategy has repeatedly collided with judicial boundaries in 2025 and early 2026. The February 12, 2026 federal ruling denying his request to pause his $10 billion defamation lawsuit did more than keep a case moving. It underscored that a sitting president cannot selectively invoke the burdens of office to delay litigation he personally initiated. The judge's refusal to grant a stay was grounded in procedural consistency. Federal civil rules apply uniformly, and plaintiffs do not receive indefinite flexibility simply because they occupy high office. Legal observers immediately framed the decision as a credibility test for Trump's broader argument that presidential responsibilities justify procedural accommodation. The court rejected that premise outright, reinforcing that the judiciary, not the executive, controls docket management and litigation pace. But this moment of accountability extends beyond a single case. In late 2025, when a federal appellate panel invalidated aspects of interim prosecutorial appointments tied to the administration, it forced the dismissal or suspension of certain prosecutions that relied on that authority. That ruling was particularly damaging because it implicated structural compliance failures rather than discretionary policy disputes. Appointment power is a constitutional function bounded by statute in the Appointments Clause, and when courts determine that those boundaries were crossed, it reflects not political disagreement, but institutional correction. The administration defended its actions as legally justified and necessary for continuity, yet the appellate opinion emphasized textual statutory interpretation over executive flexibility. The contrast between the White House's public defense and the court's reasoning sharpened perceptions of constitutional tension. Immigration enforcement controversies added further layers of responsibility. Federal judges in early 2026 ordered procedural safeguards restored in cases where plaintiffs argued that removals occurred without adequate due process protections. In written opinions, courts emphasized that enforcement urgency cannot override constitutional guarantees embedded in the Fifth Amendment. That language signaled judicial impatience with arguments that executive priorities justify compressed review standards. When courts invoke constitutional text explicitly and repeatedly, they are not merely issuing narrow injunctions. They are documenting a pattern of overreach in the judicial record. For critics of the administration, those opinions serve as evidence of systemic boundary testing. For supporters, they represent judicial resistance to executive agenda implementation. Either way, responsibility is assigned through formal legal reasoning, not political rhetoric. Another flashpoint centers on the administration's approach to federal benefit program adjustments reviewed in 2026. When district courts required agencies to maintain statutory funding compliance pending appeal, they highlighted discrepancies between administrative guidance and legislative mandates. Judges stressed that executive agencies cannot reinterpret appropriations frameworks absent clear congressional authorization. That message reinforces a core separation of powers principle. The power of the purse rests with Congress, and the executive's role is execution, not alteration. Each time courts restate that hierarchy, they implicitly critique decisions that blurred it. Public messaging from the White House has frequently characterized adverse rulings as temporary setbacks or partisan judicial activism, while legal filings emphasize constitutional authority and administrative discretion. Yet judicial opinions consistently return to statutory text, procedural compliance, and constitutional limits. That divergence between political framing and judicial reasoning fuels the controversy. When courts articulate detailed justifications grounded in precedent and separation of powers doctrine, they establish a paper trail that historians, legal scholars, and appellate courts will examine for years. Accountability in this context becomes cumulative. Each rebuke adds to an evolving judicial narrative about executive reach. The refusal to pause Trump's own lawsuit proceedings crystallizes the broader issue. By denying delay, the court asserted that personal litigation decisions carry consequences independent of political office. Discovery will proceed, depositions will occur, and deadlines will stand. The presidency does not suspend procedural law. Combined with appellate reversals on appointments and injunctions on enforcement actions, the pattern signals that courts are not deferring reflexively to executive assertions. Instead, they are scrutinizing them with heightened rigor. Responsibility, therefore, is no longer an abstract debate. It is documented in written orders, appellate opinions, and enforceable injunctions. Judges are placing constitutional boundaries in explicit terms, and the administration must navigate within them. Whether viewed as constitutional guardrails or judicial obstruction, the record shows a presidency confronting sustained institutional resistance, and a judiciary determined to define where executive authority ends. The long-term consequences of this judicial confrontation are no longer theoretical, they are forming in real time, and the direction they take could permanently redefine the balance of power between the presidency and the courts. Since returning to office in January 2025, Donald Trump has pursued an assertive executive agenda, but the steady series of rulings through late 2025 and early 2026, capped by the February 12, 2026, denial of his request to pause his $10 billion defamation lawsuit, suggests that federal courts are prepared to impose firm procedural and constitutional boundaries. When a judge refuses to delay litigation initiated by a sitting president, it sends a durable message. Executive authority does not eclipse judicial independence. That principle, once reinforced through written opinions and appellate affirmations, becomes precedent that shapes future disputes not only for this administration, but for any presidency that follows. If this pattern continues, the most immediate impact will be institutional caution inside the executive branch. Agencies facing repeated injunctions and adverse rulings are already expanding internal legal review processes to avoid being overturned under the Administrative Procedure Act. Career attorneys are reportedly requiring more detailed evidentiary records and statutory analysis before major regulatory changes are finalized, anticipating stricter judicial scrutiny. That shift slows implementation timelines, increases bureaucratic layers, and reduces unilateral flexibility. For supporters of expansive executive action, this represents friction and delay. For constitutional scholars, it reflects the intended function of checks and balances. Either way, the presidency becomes operationally constrained by the expectation of near-automatic litigation and rigorous review. Another forward-looking consequence lies in the appellate pipeline. Several disputes tied to immigration enforcement, administrative authority, and appointment powers are moving upward through federal circuits, and legal analysts anticipate that at least one major separation of powers case could reach the U.S. Supreme Court during the 2026-2027 term. A high court ruling that narrows executive discretion, especially regarding appointment mechanisms or enforcement authority, would carry nationwide binding effect. Conversely, a ruling that affirms broader presidential latitude would recalibrate lower court resistance. The stakes are therefore structural, not episodic. What is unfolding now could define how far a president can go in interpreting statutory authority without explicit congressional endorsement. Political consequences are equally significant. Extended litigation timelines, including the scheduled February 2027 trial in Trump's defamation case, ensure that legal scrutiny remains a sustained feature of the national conversation. Court-mandated discovery processes may generate document disclosures and sworn testimony that shape public perception regardless of ultimate verdicts. The presidency, in effect, becomes intertwined with active courtroom proceedings for an extended period. That dynamic can influence legislative negotiations, electoral messaging, and international diplomatic optics. Allies and adversaries alike monitor domestic institutional stability, and visible friction between branches can affect perceptions of governance predictability. Public trust will likely continue to fragment along partisan lines. Surveys in early 2026 already indicate widening divides in confidence toward both executive leadership and the federal judiciary. If courts persist in rebuking executive actions, supporters may interpret rulings as obstructionist, while opponents may view them as essential constitutional enforcement. Prolonged polarization around institutional legitimacy can weaken civic cohesion, particularly when high-profile decisions dominate media cycles. The durability of democratic systems depends not only on legal correctness, but also on public acceptance of judicial authority. Economically, regulatory uncertainty linked to ongoing litigation could persist. When agencies hesitate to finalize rules or reverse policies due to anticipated court challenges, businesses face shifting compliance landscapes. Markets value predictability. Repeated reversals or injunctions complicate long-term planning. Immigration rulings, benefit program adjustments, and enforcement authority questions all intersect with workforce stability, consumer confidence, and fiscal projections. Even temporary court orders can ripple through supply chains and local economies. What emerges from this moment is a stark choice point. Either the executive branch adapts to a judiciary signaling strict adherence to statutory text and procedural rigor, or constitutional clashes intensify, escalating to landmark Supreme Court decisions that redraw the contours of presidential power. The question is no longer whether judicial rebukes will continue, they already have, but whether this sustained pushback will recalibrate executive strategy or deepen institutional confrontation. The future of American governance may hinge on how that tension resolves, and whether constitutional guardrails hold firm under mounting political pressure.